Ever made a deal on a handshake and then kind of wondered, would that actually hold up in court? Well, today we're going to crack the code on contracts. We'll give you the exact legal formula to figure out when a simple promise turns into something legally binding.
So let's kick things off with a scenario you've probably been in before. It seems totally straightforward, right? But in the eyes of the law, this is a bit of a minefield. Is it a done deal, or are you still negotiating? By the time we're done here, you're going to know the answer, for sure.
And here's our roadmap for getting there. We're going to break this whole thing down into 5 simple steps. Think of it as a clear framework you can use for any deal. Okay, first things first. Before we can even get into offers and acceptances and all that, there is one absolutely critical question you have to ask. It's the starting point that decides the entire rulebook for the deal. And that first question is, what law are we playing by? Think of it like a fork in the road. On one side, you've got deals for services, like hiring someone to paint your house. That puts us on the common law path, with its really strict old-school rules. On the other side, you've got deals for goods, physical things you can touch, like a car or that gaming console. That sends us down the UCC path, which has way more flexible rules built for how business actually gets done today. So what happens when a deal is a mix of both, like this kitchen renovation? You've got goods, the cabinets, the appliances, and you've got a service, the actual installation work. So, which road do we take? Well, the law has a pretty smart way to figure this out. It's called the Predominant Purpose Test. To get the answer, you just ask, what's the main point of this whole deal? In this case, the homeowner isn't just going shopping for a fridge. They're hiring a contractor for the service of renovating their kitchen. Since the service part is the main goal, and it's worth more money, the entire contract falls under those stricter common law rules. All right, so once we've picked our path, common law or UCC, we know which rulebook we're using. The next step is to find that first essential building block of any contract, a valid legal offer. Now, a real offer is way more than just talking about a deal. The law needs to see that someone is serious, like ready to be bound right now serious. That means their words have to show a clear intent, include the must-have details like price and how many, and be aimed at a specific person or group.
This brings up a really good question about ads. Aren't they usually just considered an invitation to come check things out? Is this ad any different?
And yeah, normally you'd be right. Ads are just invitations. But this one actually crosses the line and becomes a binding offer. And why is that? Because it is just so specific. It lays out the exact quantity, the exact price, and exactly who can accept, the first people to show up. There's literally nothing left to negotiate. Okay, now we're getting to the really interesting part. This is where most deals get complicated, and it's exactly where we're going to find the answer to our gaming console question. We have an offer, but now we need an acceptance. Back on that common law path, remember the one for services, the rule is, well, it's brutally simple. It's called the mirror image rule, and it means what it says. Your acceptance has to be a perfect, identical reflection of the offer. If you change one tiny thing, you haven't accepted anything. You've actually rejected the offer and made a brand new one. And this, right here, is where those two paths we talked about go in completely different directions. The UCC, for goods, looked at that strict mirror image rule and basically said, no thanks. It was designed for the real world, where saying yes, but doesn't automatically kill the whole deal. Under the UCC, you can add new terms and, believe it or not, still have a contract. The specific legal tool that makes all this possible is UCC Section 2207. Lawyers have a great name for it. They call it the Battle of the Forms. It was made for the very common situation where a buyer's purchase order and a seller's invoice don't match up perfectly. So how does this work with those new terms? It really all comes down to who is making the deal. If you've got at least one regular person, a non-merchant, then any new terms are just considered proposals. But if both people are merchants, meaning they do this for a living, those new terms can get automatically sucked into the contract. And that brings us all the way back to our gaming console. Selling a console is a sale of goods, so we use the flexible UCC rules. The friends text deal, but you have to include the controller, actually counts as an acceptance of the original $200 offer. That bit about the controller, it's just a new proposal. The seller can say yes or no to it, but either way, they already have a deal for the console at $200. So, we've got an offer, we've got an acceptance, that means we have an agreement. But wait, we're not done yet.
To make this thing a truly enforceable contract, the law demands one last, absolutely crucial ingredient.
And that ingredient is called consideration. It's a fancy legal term, but you can just think of it as the price of the promise. It's what separates a real contract from an empty promise, like saying you'll give someone a gift. For a contract to be real, there has to be a bargained-for exchange where both sides give up something of value.
Okay, so keeping that definition in mind, take a look at this. Can you spot the problem? Is there a real bargained-for exchange happening here?
Nope, no way. The law calls this an illusory promise. That key phrase, "if I feel like it," blows up the whole deal. It means the speaker hasn't actually committed to anything. And since one side isn't really on the hook, there's no mutual exchange, no consideration, and that promise is totally unenforceable.
Okay, let's pull all these pieces together now into one simple checklist you can use to analyze pretty much any deal that comes your way.
It really just boils down to these three questions. First, what's the law? Is it goods under the UCC or services under common law? Second, do we have an agreement? Look for that solid offer and a valid acceptance, making sure to use the right rulebook. And third, is there consideration? You got to make sure both sides have some skin in the game. And that really gets to the heart of it, doesn't it? A contract isn't just some dusty document for lawyers. It's a formula. It's the invisible framework governing our daily agreements, from buying a coffee to selling a console. It's not about the paper, it's about the process. So it makes you think, doesn't it? What promises have you made today?